Can you hear me? Can everybody hear me?
I can hear you, Your Honor. Good morning.
Good morning. Yes.
Okay, very good. Okay, we're on the record in the matter of the people of the state of Michigan versus Rashad Malik Trice, file number 23-02244FY, council appearance.
Good morning, Your Honor. Danielle Russo-Bennett, Assistant Attorney General on behalf of the people.
And
Your
good
Honor,
morning,
good
Your Honor.
morning.
LaDonna Logan on behalf of the people, Assistant Attorney General.
I'm sorry. Good morning, Your Honor. My name is Keith Watson. I am the public defender. I appear today on behalf of Rashad Trice, who appears remotely from the Newaygo County Jail, Room 2.
Today's the date and the time that is set for an arraignment. I do have a felony complaint here, Mr. Trice. It alleges that on or about July 2nd, 2023 through July 5th, 2023, and that you did allegedly, contrary to law, at the area of 3201 Beaujardin Boulevard, 13, Building 13, Apartment 107, Lansing, Michigan 48910, near Irwin Street, between Olympia and Edgewood, Detroit, Michigan, and 9 Mile Road and Harper Road, St. Clair Shores, Michigan 48080, did contrary to law commit in count 1 homicide, felony murder that you did while in the perpetuation or attempted perpetuation of a kidnapping, murder 1 Winter Cole Smith, and that this was done contrary to Michigan Compiled Law 750.3161B. That's a felony. The maximum penalty is life without parole. Your DNA is to be taken upon arrest. There's a count 2 of homicide, murder in the first degree, premeditated. The allegation is that you did deliberately, with the intent to kill and with premeditation, kill and murder 1 Winter Cole Smith, and that this was contrary to Michigan Compiled Law 750.316. This is a felony. Maximum penalty, life without parole. Your DNA is to be taken upon arrest. There's a count 3 of kidnapping, child enticement. The allegation is that you did maliciously, forcibly, or fraudulently lead, take, or carry away, or decoy or entice away a child under the age of 14 with the intent to detain or conceal such child from its parents or guardians, contrary to Michigan Compiled Law 750.350. There's a Sex Offender Registry Act notice attached to count 3. It says only where the facts establishing the conviction offense have a sexual component under People v. Lyman, Michigan Act 2022 WL 2182165 at 14. Leave granted by law. This is a tier 3 offense under the Sex Offender Registry Act that makes count 3 a felony, maximum penalty, life or any term of years. DNA is to be taken upon arrest. Count 4, home invasion first degree. Allegation is that you did break and enter or did enter without permission a dwelling located at 3201 Beaujardin Boulevard, Building 13, Apartment 107, Lansing, Michigan 48910. And while entering, present in, or exiting, did commit assault with intent to murder and or criminal sexual conduct first degree and or kidnapping, a felony or an assault, and while entering, present in, or exiting the dwelling, Samari Cole was lawfully present therein, and that this was done contrary to Michigan Compiled Law 750.11 082. That's a felony. Maximum penalty is 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 5 charges you with kidnapping, alleging that you did knowingly restrain Samari Cole with the intent to engage in the criminal sexual penetration or criminal sexual contact with that person, contrary to Michigan Compiled Law 750.349. Again, there's a Sex Offender Registry Act notice attached establishing that only where the facts establishing the conviction offense has a sexual component, that this is a tier 3 offense under the Sex Offender Registry Act if the victim is a minor. That's a felony. Maximum penalty is life in prison or any term of years and or $50,000 in fines. Your DNA is to be taken upon arrest. Count 6, criminal sexual conduct, first degree, multiple variables. It alleges that you did engage in sexual penetration, to wit, penis to genital opening with Samari Cole under the following circumstances during the commission of the felony of kidnapping and or home invasion and or assault with intent to murder, and or that you were armed with a weapon or any article used or fashioned in a manner to lead the victim to reasonably believe it was a weapon, that this was done contrary to Michigan Compiled Law 750.520B. Again, there's a Sex Offender Registry Act notice that says this is a tier 3 offense under the Sex Offender Registry Act unless the court finds that the victim was between the ages of 13 to 15 inclusive, consented to the conduct, and the defendant was not more than 4 years older than the victim under Michigan Compiled Law 28.72254. There's an HIV STD testing notice. It alleges or states here, take notice that pursuant to Michigan Compiled Law 333.5129, upon bind over to the circuit court or courts or recorder's court, the district court judge shall order the defendant to be tested for sexually transmitted infection, hepatitis B infection, and or the presence of HIV or any antibody to HIV if the judge determines there's reason to believe the violation involves sexual penetration or exposure to a body fluid of the defendant. If the district judge determines the testing is not required upon conviction, the court must order the defendant to be tested. Felony is the maximum penalty here. Life, mandatory lifetime electronic monitoring, mandatory AIDS, STD testing, and DNA is to be taken upon arrest. The court may impose a consecutive sentence under MCL 750.520B3. Count 7, criminal sexual conduct, first degree, multiple variables, again alleges that you engage in sexual penetration, to wit, fellatio, with Samari Cole under the following circumstances during the commission of a felony of kidnapping and or home invasion and or assault with intent to murder and or armed with a weapon or any article used or fashioned in a manner to lead the victim to reasonably believe it was a weapon, and this was done contrary to Michigan Compiled Law 750.520B. Again, the Sex Offender Registration Act notice, right in count 6, is attached here to count 7. There is a HIV STD testing notice, the same that was read in count 6, is attached as well to count 7. This is a felony. The maximum penalty is life and or mandatory electronic monitoring, mandatory AIDS, STD testing, DNA to be taken upon arrest, and the court may impose a consecutive sentence under MCL 750.520B3. Count 8 is assault with intent to murder. It alleges that you did make an assault upon a Samari Cole with the intent to commit the crime of murder, contrary to Michigan Compiled Law 750.83. That's a felony. Maximum penalty, life or any number of years. Your DNA is to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 9, motor vehicle unlawful driving away, alleges that you did willfully and without authority take possession of and drive or take away or did assist in or was a party to such taking possession, driving, or taking away of a motor vehicle, that being a Chevrolet Impala belonging to another, that being belonging to a Willeen Donald, and that this was done contrary to Michigan Compiled Law 750.413. That's a felony with the maximum penalty 5 years. The Secretary of State is to suspend your driver's license for 1 year under MCL 257.3192B. Count 10 is stalking. It alleges that you did engage in the willful course of conduct involving repeated or continuing harassment of Samari Cole, the conduct being such that would cause a reasonable person to feel terrorized and or frightened and or intimidated and or threatened and or harassed and or molested. And such conduct did cause Samari Cole to feel terrorized or frightened or intimidated or threatened or harassed or molested. This is contrary to Michigan Compiled Law 750.411H. Restitution may be ordered in this offense, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual under MCL 780.811A. This is a misdemeanor. Maximum penalty 1 year and or $1,000 in fines and up to 5 years probation. Count 11, domestic violence, alleges that you did make an assault or assault and battery upon a Samari Cole, an individual with whom you had a child in common, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered in count 11, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. That's a misdemeanor with the maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 11 has a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.813 on or about June 23rd, 2021, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814. Restitution may be applied in count 11, as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. The second offense notice makes count 11 a misdemeanor with the maximum penalty enhanced to 1 year and or $1,000 in fines. Again, a consecutive sentence may be imposed if the assault was committed in a place of confinement. Count 12, stolen property, receiving and concealing $1,000 or more, but less than $20,000. It alleges that you did buy, receive, possess, conceal, or aid in the concealment of a motor vehicle stolen, embezzled, or converted property, knowing or having reason to know or reason to believe that the property was stolen, embezzled, or converted, and that the value was $1,000 or more, but less than $20,000, and that this was contrary to Michigan Compiled Law 750.5353A. That's a felony, maximum penalty 5 years and or $10,000 in fines, or 3 times the value of the property, whichever is greater. To impose a fine of 3 times the value, the defendant must either admit the amount or it must be determined by a trier of fact at trial. The court may order reimbursement to the state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution under MCL 769.1F. Count 13, stolen property, receiving and concealing a motor vehicle, alleges that you did buy, receive, possess, conceal, or aid in the concealment of a Chevrolet Impala, a stolen motor vehicle, knowing or having reason to know or reason to believe that the vehicle was stolen, embezzled, or converted, and that this was done contrary to MCL 750.5357. This is a felony. Maximum penalty is 5 years and or $10,000 in fines, or 3 times the value of the motor vehicle, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact. The court may also order reimbursement to the state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution, and this is under MCL 769.1 Act. Count 14, police officer fleeing second degree under the vehicle code. It alleges that being a driver of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by D. Jacquemin, a police officer who was in uniform, and the officer's vehicle was identified as an official police vehicle acting in the lawful performance of his or her duty, directing the defendant to bring his or her motor vehicle to a stop, did willfully fail to obey such direction by increasing the speed of the motor vehicle and or attempting to flee or elude the officer, and that this was done contrary to Michigan compiled law 257.602A2. And it further appearing that on January 7th, 2022, said defendant was previously convicted of third degree fleeing and eluding in the 44th Circuit Court. Therefore, this violation of Michigan compiled law 257.602A constitutes second degree fleeing and eluding contrary to Michigan compiled law 257.602A4. This is a felony with a maximum penalty 10 years and or $5,000 in fines. Secretary of State is to revoke the operator's or chauffeur's license under MCL 257.303. Count 15. Peace officer disarming firearm. It alleges that you did take a firearm from the lawful possession of Josh Ballard, a peace officer with the East Point Police Department, and that this was done contrary to Michigan compiled law 750.479B2. This is a felony. Maximum penalty 10 years and or $10,000. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 16, assault with a dangerous weapon, also called felonious assault, alleges that you did make an assault upon a David Ely with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That this was done contrary to MCL 750.82. That's a felony. Maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Did we lose Mr. Watson? He doesn't have his audio on. Can you hear us, Mr. Watson? You're muted.
Yes, Your Honor, thank you. I can hear you now. I, for some reason or another, I had a difficulty with the internet connection here from the Justice Center in Mason. When last I was, Your Honor was reading count number 15.
Okay, yep, that was the last count I believe I read. Oh, nope, I went to count 16, which is assault with a dangerous weapon, felonious assault, charging Mr. Trice with allegedly making an assault upon David Ely with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to Michigan compiled law 750.82. And that count 16 is a felony with the maximum penalty of 4 years and or $2,000. DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Count 17 is police officer assaulting, resisting, obstructing, causing injury. The allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger David Ely, a police officer of St. Clair Shores Police Department, and that the defendant knew or had reason to know was performing his or her duties and caused bodily injury requiring medical attention or medical care to that person, contrary to MCL 750.81D2. That's a felony with a maximum penalty, 4 years and or $5,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. Count 18, police officer assaulting, resisting, obstructing, alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger D. Jacquemain, a police officer of St. Clair Shores Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to Michigan Compiled Law 750.81D. That's a felony with a maximum penalty, 2 years and or $2,000 and fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. Count 19, another police officer assaulting, resisting, obstructing, alleging that you did assault, batter, wound, resist, obstruct, oppose, or endanger in Jacquemain, a police officer of the St. Clair Shores Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to MCL 750.81D1. Felony with a maximum penalty, 2 years and or $2,000 in fines, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. Count 20, police officer assaulting, resisting, obstructing, alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger Josh Ballard, a police officer of East Point Police Department, that the defendant knew or had reason to know was performing his or her duties contrary to Michigan Compiled Law 750.81D1. That's a felony with a maximum penalty, 2 years and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. There's a habitual offender fourth offense notice. It indicates here, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about January 7, 2022, he was convicted of the offense of fleeing and eluding third degree in violation of MCL 257.602A3A and 44th Circuit Court for Livingston County, State of Michigan. And on or about January 7, 2022, he was convicted of the offense of felonious assault in violation of MCL 750.82 in the 44th Circuit Court for Livingston County, State of Michigan. And that on or about January 7th, 2022, he was convicted of the offense of felonious assault in violation of MCL 750.82, also in the 44th Circuit Court for Livingston County, State of Michigan. And that on or about January 7th, 2022, he was convicted of the offense of resisting, obstructing a police officer in violation of MCL 750.81D1 in the 44th Circuit Court for Livingston County, State of Michigan. And then on or about January 7th, 2022, he was convicted of the offense of resisting and obstructing a police officer in violation of MCL 750.81 D1 in the 44th Circuit Court for Livingston County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.12. The penalty is life if primary offense was or has a penalty of 5 years or more, 15 years or less if the primary offense has penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. Mr. Trice, do you understand each of the charges read in counts 1 through 20 and the maximum penalty attached? Mr. Trice, can you hear us? Okay, Mr. Watson, I'm not sure if your client can hear us or if he is electing to stand mute at this time.
Well, Your Honor, as to the charges, Mr. Trice will stand mute and ask that plea of not guilty be entered on his behalf on each of these charges. Thank you.
Okay, the court will enter a plea of not guilty as to each count. Mr. Trice has the following rights. He has the right to remain silent. Anything that he says, anything that he puts in writing can be used against him. He has the right to plead guilty. He has the right to plead not guilty and again stand mute, which it appears as of today, he is electing to stand mute. He has the right to have a preliminary examination within 21 days of today's date being the date that he was arraigned as to the new complaint with counts 1 through 20 at the time of the preliminary examination. And that's a preliminary examination only as to the felony charges. He has the right to have the prosecution in this matter, being the Office of the Attorney General, to put forth sufficient evidence to establish whether or not they have sufficient probable cause to each felony count. So they have to establish, Mr. Trice, that there's sufficient probable cause that a crime is committed and probable cause to charge you with each of the felony counts. You have the right to proceed to a trial and you have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to have the prosecution prove your guilt by proving first each element of each of the charges being brought against you beyond a reasonable doubt at trial. You have the right to confront in court any of the witnesses called against you, and you have the right to cross-examine those witnesses. You have the right to call your own witnesses to trial or present evidence at trial that you believe further defenses to the charges being brought against you. You also have the right to be represented by counsel. You are already represented by the Office of the Public Defender, but you have the right, if you cannot afford to hire an attorney, to have a court-appointed counsel appointed at the expense of the public. This matter is scheduled for probable cause conference on August 4th, 2023 at 9:30 in the morning before me, and that'll be via Zoom. There's a preliminary examination that's scheduled at this time for August 11th, 2023 at 9 o'clock in the morning. Did the prosecution want to address bond? And then Mr. Watson, you can address bond.
Your Honor, given the serious nature of these charges, as well as the fact that if the defendant were convicted as charged, he's looking at life without parole, we would ask that the court not enter a bond and leave it at remand status.
Thank you. Mr. Watson, you can address bond.
Well, Your Honor, there's a certain practicality to this as well. Mr. Trice is presently in federal custody in Newaygo County Jail. I ask that Your Honor exercise your best judgment concerning bond. Thank you.
Due to the nature of the charges that are pending before the court, as well as circumstances involving his custody in Newaygo County Jail. The court is inclined to believe that there is a threat to the public safety and possibly a likelihood of not returning to court if bond is posted. So under the statute, bond will be denied at this time. The defendant will remain in custody pending the prosecution of this case. We'll see.
Thank you, Your
Mr.
Honor.
Trice and Counsel, no problem. We'll see everyone back on August 4th via Zoom at 9:30 in the morning.
Thank you, Judge.
Thank you. Any additional matters for the record today?
Not from the people.
Nothing further from the defense. Thank you very much, Your Honor.
Thank you. You're all set.